Hi everybody, welcome to Law Hero. So we're here to discuss the company's exam from the FE1 in March 2019, and actually having read the exam report, only 58% of people passed it. This is astounding to me because it means that there is some gap in understanding, and I'm here to basically try and discuss what the issues may be and also provide a solution if you're struggling. So stay tuned and make sure you like and subscribe. It really helps and it keeps me motivated to make more of these videos. Okay, question 1, ultra vires. Why you need to get into your head is private limited company has complete power to do anything. That means you don't need an objects clause in your constitution because you can do whatever you want. You don't need to list what you're going to do. This is not the case for any other company, and I'm talking about unlimited companies, public limited companies, companies limited by guarantee, and DACs, designated activity companies. The reason these companies still have objects is because they're set up for a certain reason, and there's more at stake with those type of companies. The lowest risk type company is the private company limited by shares. But then you ask, what is the point of ultra vires if I'm a private limited company, I can do whatever I want? There is no ultra vires for private limited companies anymore. There is still ultra vires for all the other companies, but it no longer affects third parties, because if I'm transacting with you and you're anything but a private limited company, I don't have to look into your constitution anymore to see if the validity of your act is backed up by your constitution. The only reason objects and ultra vires are important now is for directors, because it's the directors that are acting ultra vires, and that contravenes their duties under the Act. Question 2 is transactions with the company. Sometimes directors need to transact with the company. It depends on what the basis of the transaction is. If it's property, it's a non-cash asset. If it's a lease or a loan, it's considered a credit transaction. Non-cash asset is section 238. Credit transaction is section 239. That could also be a guarantee. These come up all the time in practice, so you might as well just learn it now. Section 220 is important because it's not just a director you're transacting with, it could also be a connected person of a director. A connected person could be a company which the director is in control of, which is normally 50% of the shares or voting rights, or a connected person under section 220 could be their spouse, their family member, somebody like that. So that's how it actually works. But then there are exemptions to these types of transactions, right? So section 240 is a de minimis threshold. That means the value of the transaction is so low, there's no need to worry about going through the whitewash procedure. The whitewash procedure is now called a summary approval procedure, and that's set out at sections 202 and 203. You will have these in your Companies Act, so you simply just need to apply them. The other thing as well is you may have an intra-group exemption. So transactions for credit transactions or property transfer between companies, that will be subject to the intra-group transaction, and that means you do not have to go through the whole rigmarole, which is great. Then there are other exemptions, section 224, director's expenses, section 245, business transaction if the lease or credit transaction is in the ordinary course of business and is at arm's length. For section 238, remember it goes both ways. If you're doing the summary approval procedure at one side, as in if you are, if it's the shareholder of the vendor, the purchaser also has to do the summary approval procedure, whereas this is not the case for section 239. Question 3 was distributable reserves. I predicted that this was going to come up. Not going to go through question 3 because distributed reserves is so straightforward. Just go to section 117 of the Companies Act and it will give you what you need. Question 4 would have been, back in the day, considered very easy, but I think Dr. Tom Courtney is getting annoyed with people's blasé approach to the advantages and disadvantages of incorporation. And I personally think the reason people are failing company law is because they're not considering the rationale of the law. Why do you think company law came about in the first place? Well, it was to encourage commerce. It was to ensure that if I went into business, and if I fail, that you're not all going to come and take my house from over my head or take my furniture just because I made a business mistake. It's basically to ring fence liability, and that was the whole point. You know, in the late I think it was 19th century, you know, the time of Solomon, and when all that stuff started, they encouraged commerce by using this separate legal personality. And it's a legal fiction, but it's there to encourage people to get into business. So you need to consider the rationale of what he's asking and take a step back and just stop rattling off what you've learned and really take a holistic, wholesome approach. There are disadvantages to incorporation. You have to make returns to the company's office. You have to adhere to your director's duties. If you hire a company secretary, you need to make sure that they have the skill to do their job. You need to have a constitution. You need to maintain registers and minutes. You need to instill corporate governance. It's not just as simple as setting up a company. And that is a distinct disadvantage to setting up a company. The advantages, though, is that you're de-risking your business. And also, you know, you can take advantage of certain legal concepts like a floating charge, which you couldn't if you were a partnership or a sole trader. Like, for example, you know, if you are trading some kind of stock, you can, when you're going for a loan, you can use that stock as security. So that's another advantage. If you're taking out an insurance policy, the insurance policy doesn't have, you know, the premium might be lower because you're a company rather than an individual. And if somebody is suing you, they're suing the company and not you. So there's loads of different things, but you need to think about the rationale rather than just jumping in and being like rattling them off, because that's not going to help you. Undisputed debt, as in your debt is bona fide. What you owe me is not to be disputed. It's simple as that. You owe me 500 quid. There is no dispute. That is a bona fide debt. But things get kind of messy when I owe you a little bit and you owe me a little bit, and that's what this whole question is about. It's like, you know, you will apply to the court and you'll be like, look, this person owes me something. If your debt is in dispute, you're not going to automatically get what you're owed. That's just the simple, that's what this essay is getting at. So yeah, you know, you need to make sure that you settle debts quickly and expediently, and again, the rationale is to encourage commerce and not arguments. Question 6 was examinership, and I also predicted that examinership was going to come up because it is completely underutilized as, you know, as a rescue procedure for companies who are failing. Like, you know, a lot of these companies are going concerns and they do have very good reputation, they do have goodwill, they could possibly trade it out. It's just easier and cleaner to appoint a receiver or a liquidator and just fire sale the whole thing off and try and recover some money. But there are some companies that do petition for an examiner and do make it through. And by the way, we've had our first female examiner in the last 2 weeks. You may have seen that in the papers and the legal news. So there are a few things you need to bear in mind if you do want to appoint an examiner, and that's if a receiver has been appointed in the last 3 days, you can't appoint an examiner. And you know, the reason for that is because you don't want to thwart the receiver's job. So you need to act fast. The other thing as well is there's loads of case law, but you know, you do get this court protection for 70 days, and you get court protection under section 520, and there's a number of consequences which come for this protection as against your creditors and the rest of the world. And then the examiner, then, you know, they have certain duties as well while they're in that position. So it's a lovely question if you know it. So the last question relates to improper transfer of assets. So again, always go back to first principles and what is the rationale. If I know that my company's heading down the tubes, I might make some transfers, or I might do some dodgy things just to avoid paying my creditors down the line. But statute has intervened and will kind of, invalidate those acts if they have been leading up to the time where I was trading improperly. So for example, if it was in the last 12 months and a transfer was made to a connected person, that might be invalidated. And that's what improper transfer is. It's like you're trying to avoid your duties under the Act, and a liquidator has the power to invalidate these. And then the other type is called an unfair preference, and section 604, and where the preference is of a person who is a connected person of the director of the company, a 2-year period is relevant, and there's an evidential presumption that it is deemed to give a preference. So you need to rebut that presumption. Thank you for watching. I really want people to understand the rationale of company law, and you know, I feel like this is where people are falling down. I think this is why there is such a high failure rate, is because people aren't actually taking a step back and going, if I was a shareholder, if I was a creditor, if I was a director, how would this actually affect me? All of this, as you will see from my website, I'm just going to click here and it'll be linked. And yeah, please have a look at my notes, because they are all encompassing and they got you covered for the exam.